Hi, my name's Greg Mailer and I'm going to talk about investigations by HMRC under COP9. The key difference between HMRC and other investigating agencies is that, unlike other investigators, HMRC is a discretionary prosecutor. Whereas other agencies who suspect criminality are only able to deal with the matter through the criminal process, HMRC have the discretion to deal with suspected fraud by criminal investigation with a view to prosecution or by way of a civil settlement under COP9. Whilst COP9 can certainly be unpleasant and stressful, there is no doubt that a criminal investigation is far worse. At BCL, we have substantial experience in successfully guiding potential criminal investigations onto the civil track, and we also work with clients and accountants in order to ensure the most favourable outcome once the case is being dealt with under the COP9 procedure. As I've said, the COP9 process can be daunting and stressful for clients, and it is, frankly, somewhat invidious in its nature. Whilst it's possible for taxpayers to approach HMRC and ask to make a disclosure of wrongdoing under COP9, more typically, the first an individual knows about a COP9 investigation is when a letter from HMRC lands on their doormat. The essence of the letter is that the taxpayer is told that they are suspected of having committed tax fraud. However, HMRC give no hint as to the basis of their suspicion, nor any details about the alleged fraud itself. The taxpayer is told that if they fess up to their undisclosed crime, then they'll be given immunity from prosecution for that crime. Now, it is important to recognise that the immunity is only offered in respect of the specific criminality disclosed by the taxpayer to the revenue. Following receipt of the letter, the taxpayer has 60 days to decide whether or not to accept HMRC's offer of immunity and enter into the Contractual Disclosure Facility, or CDF, or to reject it. It can be very difficult in those first 60 days for the taxpayer to decide whether or not to accept HMRC's offer. Often, the taxpayer has no idea whatsoever why the revenue might suspect they've committed fraud, and so the first thing that we do with our clients is to work with them in order to try to ascertain where the revenue might be coming from and whether their suspicions might be well founded or not. At the end of that 60-day period, the client then has a choice: either to reject the offer, where they do not accept that they've acted deliberately, or to accept the offer and make a full disclosure of their deliberate behaviour. The admission will then result in higher financial penalties. More importantly, it is crucial to ensure that any information or answers given to the revenue are entirely accurate. If a disclosure is made which appears to be inconsistent with anything that the taxpayer has previously told HMRC, perhaps in tax returns or in previous investigations or following information requests, then the repercussions can be devastating. If a confession appears not to be full and accurate, or worse, if HMRC suspect that they've been lied to, then the individual can be prosecuted not only for the underlying tax offence, but also potentially for misleading HMRC during the COP9 investigation itself. A further pitfall is that if the taxpayer does confess to criminality, but it was not the criminality that HMRC suspected in the first place, then HMRC can prosecute in relation to their original suspicion, plus the taxpayer, having already owned up to a separate crime that the revenue didn't even know about, will then face prosecution as a self-confessed fraudster. There are other important factors to bear in mind when considering COP9, not least if the taxpayer is in the regulated sector, such as the financial services industry, or chartered accountancy, or law. Clients in those sectors will often be obliged to notify their regulator that they have entered into the Contractual Disclosure Facility. Even though the CDF does not involve a conviction, it does require the taxpayer to accept that they have acted dishonestly. This can have potentially harmful repercussions, for example, in relation to fitness and propriety and suitability to perform a controlled or senior management function. Clearly, the consequences of a COP9 investigation can be very wide-ranging, and the decision as to whether to enter into the facility itself in the first place can be very difficult. For our clients, the best results are those which are dealt with quietly and efficiently, without the need for litigation. We know that reputation is often a key priority, and we have a great track record in resolving investigations without them ever entering the public domain. Whilst there are many solicitors with expertise in relation to technical tax, and many others with experience in defending individuals accused of financial crimes, there are far fewer with a breadth and depth of experience in those areas combined. At BCL, we have highly ranked solicitors who are experienced in all aspects of HMRC investigations, from the opening of an inquiry or even before, until its successful conclusion, whether before a court or tribunal or otherwise.